So remember, non-competes have to be reasonably limited in both time and geography. Now, that is going to vary depending upon where you're located. And it's really often based on population density. And what is reasonable can be, frankly, can be very, very subjective. Um, all states are different in terms of the enforceability of restrictive covenants. For example, in California, a restrictive covenant is not even enforceable in an employment arrangement. But the limitation on reasonable time and geography can vary depending not only where it is, but what type of matter we're talking about. And what I mean by that is there's a difference between an employment relationship and the sale of a practice. In an employment relationship, courts are very reluctant to enforce an extensive non-compete and limit a person's ability to work. So I always tell clients when a practice is framing the terms of a non-compete for an employee, I always talk about the reasonable limitation in time. I generally don't like to see more than 1 year in terms of hoping to have that enforced. And in terms of geography, it depends on population density. So for example, if I'm in New York City, I might be talking about neighborhoods or square blocks in terms of what's a reasonable restrictive covenant. If I enter into New Jersey, and I'm in still more of a urban area, but not in a city, geography might be somewhere in the 5 mile range, maybe the 7 mile range. As I venture further into the suburbs and people are willing to travel a greater distance for dental care, I might be looking at a 7 to 10 mile restriction. And really, for an employment relationship, it kind of taps out there unless I start getting into real rural areas. So if I start getting into like furthest areas of northern or western New Jersey or parts in the southwestern part of the state, you might see an enforceable restrictive covenant of 15 miles. Now, that varies from a practice transition. What courts have recognized is the very nature of a practice transition is a substantial amount of consideration being paid. And primarily in dental practice transitions, a lot of that is for goodwill. And courts recognize a buyer's right to protect themselves from a breach of a restriction and protect the fact that the substantial consideration has been paid for that goodwill. In those cases, it's not unusual to see a 5-year restrictive covenant for a deeper, longer geography. So when we're in a city setting, it would expand. But also when we look at the state of New Jersey, for example, you might have a 10 to 15 mile restriction pretty much anywhere on the non-compete for an asset transaction. And also remember there's usually 2 components in a practice transition on the non-compete. There's a non-compete that will typically be in the purchase agreement, and that's where you'll see a 5-year restriction for an expanded geography, which is totally enforceable. But also often a 2-year restriction contained in an employment agreement if a doctor is transitioning and staying with the practice for a period of time. And the reason it's done that way is that sometimes a doctor may stay with the practice beyond the 5 years, and the practice that purchased that office not only has the desire to protect the investment in the purchase, but also post acquisition and post 5-year restriction to make sure that in essence there's a tail on that restrictive covenant. So always remember difference between employment relationships versus practice transitions, and understanding that reasonable limitation on time and geography will vary, more conservative on employment relationships and broader on practice transitions.